Hello, welcome back again to the intellectual property law discussion. This is the continuation of the copyright part, and in this part we are going to focus on recognizing some main terms in copyright. But before I continue, I need to tell you listeners that this course is given to the business law student, which this course is the supporting and complementary course for them. So we are just going to discuss about all the topic in business law in brief. So there will be many things and many aspects that we're not going to explain. That's why I suggest you to find related references, and of course you have to spend more effort to read the regulation to know better, because in this course I'll just explain you the main part. So now we will continue to learn about some main terms in copyright. The existence of a copyright is really depend on the effort of an author. So the translation of Indonesian law number 28 2014 used the terminology author to explain someone who create a creation or a works that is protected by copyright. Nevertheless, I personally I also use the terminology of creator, which in Indonesia we call it pencipta, to identify the party who has the exclusive right upon a creation or a works. To determine who or what is an author, you can read it in Article 1 number 2 in copyright law number 28 2014. Based on the provision here, it explains that author means a person or several persons who individually or jointly produce works that are unique and personal. Once again, I repeat, author means a person. Okay, remember again the concept of a person. I've told you at the second and the third meeting when we talk about the legal subject. The concept of a person, it could be natural person, us, a natural body, or legal entity like company, PT for example, limited liability company. So who can be an author of a copyright? So it could be a person, so it can be a human being or a company, specifically legal entity. A person or several persons, so it could also made by more than one natural person or more than one company. You might be familiar with some cooperation in creation making. If you know, it's like a musician, the Beatles, most of the song of the Beatles is written jointly by John Lennon and Paul McCartney. So the entitled the song is written by Lennon McCartney. So the creation could also made by more than one natural person, and also it could be made by more than one company. So that is an order. The more explanation of who are the author, you can find it in chapter 4 in the law, that give you more explanation about it. And if we take a look at chapter 4 about author, it started with article 31. You can take a look at the regulation here. So it's mentioned here that unless proven otherwise, the one to be considered as the author is the person whose name A is stated in the works, B is stated as the author of the works, C is stated in the certificate of work recordation, and D is listed in the general register of works as the author. So it's talking about evidence of who is considered as the author. If your name is written clearly as the owner of the creation, like let's say that you register your copyright to Dirjen HKI, the Intellectual Property Bureau, then you will be issued a certificate by the bureau, and your name will be written as the author there. Then because of that, you could prove that you are the author of the creation. However, as at the previous part I told you that copyright is decorative, that's why even though someone is writtenly mentioned as the creator or the author, but if you could prove that you are the one who declared it before the one who the name is mentioned, then you would be considered as the creator. So that's why Article 31 is started with unless proven otherwise. Unless proven otherwise means if you could prove it, so even though someone claim the authorship of the creation based on a certificate, so the law will consider you as the owner. For example, someone create a song, let's say the title of the song is Love, and then he registered the Love song upon his name to Dirjen HKI, to the Intellectual Property Bureau. So the Intellectual Property Bureau would issue the certificate of the ownership. I will send you the example of the certificate through an email later. Let's say that the name is Bono. So based on the certificate, the Love song is owned by Bono, and then Bono published the song, but then you recognize that actually this is your song. So the only thing that you have to prove is that you already published this song before Bono published it. Let's say Bono published it in 1 January 2020. So you have to prove that. Maybe you could show that a YouTube video that shows that you already published that song before 1 January 2020, or maybe you were recorded while you play the song in the wedding ceremony, and you can also call some witness to confirm it. So it means that you are the first one who declared it. So if that's the case, based on this Article 31, unless proven otherwise, so if you could prove it, then even though the one is stated as the stated or listed as the owner, you could counter this claim, and even you can reclaim the authorship of the creation upon your name. So you could continue to read about it in Article 32, 33, and 34 and 35 and so on, but we'll discuss about that later. But the main one, how to know someone is entitled as the author of a creation, first because they are listed in the certificate or stated as the author of the creation. But if someone else could prove that they are the one who declared it before the one who the name is listed, then the first person who declared it will be considered as the author. And then the author, the creator, spend his time, spend his energy, money to create something that valuable economically, that we call as works or creation. So here's the point that you have to pay attention. What makes copyright different with the other intellectual property like patent, trademark? Because it's been limited. The scope of creation that protected by copyright has been limited, because there are so many kind of creation in this world, and those creation is protected in intellectual property. But then different types of creation is protected by different types of intellectual property protection. And in this case, we call the creation is under the copyright if the creation is in form of scientific, artistic, and literary works. Or in Indonesia, the Indonesian law said in types of seni, sastra, dan ilmu pengetahuan. So if it is in scientific, artistic, and in literary works, so this is copyright. Okay, so don't be confused with the patent. Later we will discuss about patent. You've watched the movie Flash of Genius, right? In Flash of Genius, the protection is not copyright, but it's patent. Why? Because it's technology. Patent is talking about technology, while creation or works in copyright is not talking about the technology. It's talking about scientific, artistic, and literary works. Artistic, for example, song, right? Song is something artistic. Literary, for example, the poem or the novel could be as well. And scientific, like a book, scientific book. So don't say, oh, technology is also scientific, but it's different. Okay, scientific here means it's give you information about knowledge, about science, but not implementally applied like technology, like in patent. And more detail about the things that protected by copyright, the creation that protected by copyright, you can read it in Article 40. So in Article 40, it's been governed in detail that the protected works, which include scientific, artistic, and literary works, comprise a. books, pamphlet, typological arrangement of published written work, and all other written works. All other written works could be including essays and other types of written works, or poems, for example. And then B, talks, lectures, like what I'm doing today, speeches, and other similar works. And then visual aids made for educational and scientific purposes, songs or music with or without lyrics, dramatic works, musical dramas, dances, choreography, puppet shows, pantomime, fine artworks in any form such as paintings, drawings, engravings, calligraphy, carvings, sculptures, or collage. Excuse me. Applied artworks, architectural works, maps, batik artworks, or other patterns art, photographic works, portraits, so on and so on. The one that is quite interesting to take a look is computer programs. But computer programs, even though it's also close with the characteristic of patent technology, but if you read the history, as also written in my book, so you could find why computer programs is included in copyright rather than this in spite of the patent, because at the time they need the law to protect the computer programs, but the law of patent was not exist, so computer programs then considered as the literary works. So remember again, the characteristic of the creation or works that protected by copyright is in the scope of scientific, artistic, and literary works. Okay, so this kind of creation must be new and not the same with the other creation. If it is the same, that it has no copyright. But if it's new, so it would gain the copyright. So when someone make the creation in the scientific, artistic, and literary works, so they get copyright, which is means they got the exclusive right to use the creation, to let the other to use it, to give the license to the other to produce it. So this is the main concept and terminology in understanding about a copyright. So are you an author? Try to take a look at the definition of author and also the classification of author. So if you are, then you could make a creation, you could make a works. What kind of works? It's been mentioned. So if it's in the scope of the creation that's protected by the copyright, then you have the copyright. Okay? Well, I hope you focus and understand this three main concept, because this would be the one that you need to understand the further discussion of this topic. In conclusion for this section, the existence of copyright is started with the initiative of an author, could be a person or a company, in creating works in form of scientific, artistic, and or literary works that is new and not copying other works, and it's been declared, so the idea of the works has been declared in a real form, so it could be accessed by the others to confirm the declaration. Then based on this circumstance, the author would obtain the copyright, which gives them the exclusive right, whether they want to use the creation by themselves. Let's say that I am a songwriter, so if I create the song, I have the exclusive right of the song. It means if I want to use it, to record it and to publish it by myself and not let others to sing it, I can. I mean commercially. But if then I don't want to produce it or use it by myself, I can let the other singer or another recording company to use my song, of course with some compensation in form of a royalty based on a license. Well, there are many things to talk about copyright actually, but I think this is one of the main part that you need to know. I will continue later with the other main part to discuss. Thank you guys.